Hey everybody, this is attorney Adam Ouellette here in Fort Lauderdale. This is the second video in a series that I'm doing. Check out the disclosure down below the video just so you understand that this video was done in late 2013 and that it doesn't create an attorney-client privilege relationship. Check that out real quick. But my company is Spectrum Title, and I'm doing a series of videos, a video on each one of the addendums, addenda plural, for the new FAR that came out here in September 2013. The first one I did was the Condominium Association disclosure, which is a whole lot longer and more in-depth than this HOA disclosure, which is what we're going to be going through today. Be on the lookout for some more of these videos. I'm recording them and sending them out usually once a week, so you can go back and check out these videos if you have questions on these addendums from time to time, because they're a little bit different than they used to be. This one not so much, but some of these other ones that I'm doing, so be on the lookout. The HOA disclosure is 1 page. The condominium disclosure is 3 pages, and this is just basically a disclosure summary required by Statute 72401, and this should be signed at the time of the offer, when the buyer fills out the offer. When you, as the agent, fill out all this stuff, the buyer should sign it. You should get this information from the listing agent if you don't have it. And we're going to talk at the end of this about the differences in what documents are required to be turned over by the seller when there's an HOA and when there's a condominium association, because it is distinctly different. And understand that there are some townhouses, quote unquote, villas they call them, that are governed by condominium associations. So you can look at the legal description and it usually will tell you whether it's a condo or not, but the listing agent should know. So the first paragraph, this only needs initials, so you don't need to sign it. Buyer and seller's information should transfer forward, as well as the legal, actually the address will transfer forward in transaction desk from what I can remember. But the buyer can cancel the contract once they get this, and it's voidable if they want. After they get the written notice, they can cancel within 3 days after receipt of the disclosure summary, which is prior to closing, whatever occurs first, their receipt of it, or 3 days prior to closing, they can cancel. Once the closing is done and this terminates, so they can't cancel for that. So fill in the name of the community there in the middle. A says that they're going to be obligated to be a member of the association, and there has been some recorded restrictive covenants governing the use and occupancy of the property. They're going to be obligated to pay maintenance per quarter, per month, whatever that is. Fill that in. If there's special assessments, put it down there in C. And this also discloses the fact that there might be special assessments that a municipality, county, or special district may impose, and all of this may be subject to periodic change. And the failure to pay an E, special assessments or assessments levied by a mandatory homeowners association, could result in a lien on the property. And the likelihood of a lien is pretty good anymore, and attorney's fees if they have to try to enforce the lien and stuff like that. So then there may be an obligation to pay rent or land use fees for recreation or other commonly used facilities. Fill that in if there is such a thing. In HOAs, there's not this kind of rec fee or anything like that for the most part, but there are a few I've seen over the years that do have them. And for developers, we in Broward County, we're kind of landlocked, and there is not a lot of development going on, even so there is some stuff downtown, but this statement contains, it says an H in the disclosure, are only summary, and the purchaser should refer to the covenant and association government documents before purchasing the property. So this is a question here, H and I, that I've gotten many times. I don't know, probably a couple hundred over the past 16 years I've been a lawyer. And that is sometimes realtors will mistakenly think that HOA documents have to be turned over, and buyers get 3 days from that point to rescind or cancel the contract, like the condominium association documents allow for in the statutes in Florida. But that is not the case in Florida, so just be aware of that, and I think that's probably the reason for me doing this video so that you understand that in I it says these documents are either matters of public record and can be obtained from the record office in the county where the property is located, or are not recorded and can be obtained from the developer. Basically, what I would suggest you doing is when the title agent orders the title, ask them to order whatever they can in terms of governing documents, the declaration, bylaws, rules, and regulations. Sometimes it's called a declaration on HOA, but that's a lot of times that's condo. But basically, there is covenants and restrictions that the association has recorded 99% of the time, and the title agent can order that stuff. So, I mean, if you're using us, let us know. We can order whatever is there, and we can get it via PDF, and it gets to us pretty quickly, a couple days. We can email it out. But that is something that the buyers should be aware of, and as an attorney, I would suggest the buyers reviewing that stuff. You don't want them coming back after closing and asking you why you didn't alert them as to whatever rule or regulation that they may be violating as of post-closing, and you don't want to have to answer those questions. So, a lot of the stuff I teach is a little bit anal, but the fact is I've seen lots of litigation over the years and been involved in, as an attorney, litigation between buyers and sellers, and even real estate brokers against all kinds of people. And these tips I give you are only to keep you out of court and to keep you out of trouble. So thanks for joining me. Be on the lookout for the next video, which is going to be about seller financing. And I appreciate your time. I hope you got some information out of this. If you have questions, feel free to give us a call at 954-727-3347. Again, this was Adam Ouellette, and I hope you have a great day.